welcome back. This week we're moving on and we're going to be talking about some specific crimes. So we've spent the last 6 weeks going over all of the rules and procedures and everything governing criminal law, the elements, how we have criminal liability and meet all of the things to keep our wheel of criminal justice still flowing. So now we're going to move on and we're going to be talking about specific crimes, okay? And then what we're going to integrate into the lecture is how to answer your homework from now to the end of the semester, your case studies. So how the rest of the semester is going to go is that I'm going to be teaching you specific crimes in the lecture. And then we'll be talking about how New York defines each of those. And then I'll give you some problems in the lecture where you're going to try to apply New York law to them. And then you're going to have a case study, which is your assignment for each chapter. So then you have to determine what crimes to charge. So throughout all of this, you're going to be the prosecutor. I'll teach you the crimes and I give you scenarios. You have to decide what crime you would want to charge, and you have to follow a specific format for answering those questions. Okay, so that's how we're going to be doing it. Another thing that you'll find very helpful for each chapter, I've created reference guides. So there's lots of different crimes for each of the different things we're going to talk about. And I tried to create sort of a concise reference guide to help you narrow down the possible crimes that could be used. So just remember on your homework and on your tests, I'm going to be really specific, asking you like, what is the homicide crime you could choose? What is the parties to crime you can choose? So make sure you read the questions very carefully and only give me the crimes that we talked about with that specific topic. You don't have to look up every single crime that exists in the criminal penal law. You just have to identify the crimes that exist that we were talking about in that week's materials. Okay, so with that background, let's get started. This week we're moving on and we're going to be talking about what is the crimes of being a party to a crime. So one of the things I've talked about over and over is, can someone be responsible for someone else's action? So I said, you need to meet all of the elements for the wheel of justice for criminal liability: actus reus, mens rea, concurrence, harm, causation. But what if you personally don't commit the actus reus? What if someone else commits the actus reus? Is that still going to be okay? Can you still be charged for somebody else committing the actus reus? And this is based on the idea of what we call complicity. Is the person complicit into the act, even if they don't personally commit the criminal actions? So we are going to be looking at all the different times where somebody could be complicit and could be responsible for crimes, okay? Now, when you're talking about parties to crime, common law broke the parties down into 4 main categories. You had what was called the principal in the first. The principal in the first was somebody that was there and actually committed all of the elements themselves. So everything we've talked about with elements, that's the principal in the first. It's the main person that does commit all of the actus reus. Now, principal in the second, sometimes you have somebody that's there and they don't themselves commit all of those actus reus. That's going to be the principal in the second. So it's somebody that's there and maybe helps the person do it, but they didn't actually commit the crime themselves. That's a principal in the second degree. Now, sometimes you have what we call accessor after the fact. So after the crime was committed, they do something to help the person escape justice, to keep the police from arresting them, to keep the prosecutor from prosecuting, destroying evidence, hiding people. That's what we call an accessory after the fact. They help after the crime is committed. And then we have accessory before the fact. That's help somebody before they actually commit the crime. So they buy the weapons, or they scope out the place, or they give the person their schedule to follow. That's an accessory before the fact. Now, it's important to remember under common law, all of these were treated the exact same. So the law didn't really distinguish between these 4 levels. If you were a principal, you were punished the exact same way as if you were an accessor after the fact. Even though the accessor after the fact wasn't there when the crime was committed, since they helped somebody commit that crime, you were going to get the same punishment as the person that actually committed the crime. So common law treated them all the same. And make sure you understand these distinctions. Now, in more recent times, we don't have 4, we only have 2. But you still need to know what those definitions are because they are still used today. And I want you to understand what they are. But what we've done now, we've narrowed all the crimes down to 2 basic categories: accomplices and accessory. So we're going to spend the rest of the lecture going between these 2 different concepts. So we're going to start with accomplice. An accomplice is someone who aids and abets another. So it's important to remember an accomplice is not the person that actually commits the underlying crime. They help somebody else commit the crime. So they personally are not committing the actus reus. They're helping the other person commit that crime. Now, so who is the principal in the first? It would be the woman, right? And who is the accomplice? It would be the man holding the person's arms, okay? So that is how we distinguish between accomplice, the person who's helping the principal in the first, but's not committing the crimes themselves. Now, how do we find somebody guilty of accomplice liability, which is a crime to be an accomplice? We have to figure out what the elements of accomplice liability are. So just like we talked about with all the elements and the wheels, these are crimes, so they have their own mens rea and actus reus. So we're going to go through and identify what's the mens rea necessary, what's the actus reus necessary for each of these crimes. So for accomplice liability, what you have to do for actus reus is 1 positive act to aid the offender. So you just have to do 1 thing that would help the principal in the first. So in our picture, what is he doing that aids the principal in the first? He holds her hands. So that is what makes it satisfy the actus reus, some positive act, okay? Now, how much of a positive act does it have to be? So what if you just provide word of encouragement? You can do it, you can do it. What if you buy the guns or supplies? What if you serve as the lookout? What if you send the victim to the principal so the crime can occur? So the principal wants to kill somebody and you say, oh, go see Joe. And you know Joe's going to kill him when he sees him. What about preventing a warning from reaching the victim? So you know Joe's going to get killed and you keep somebody else from warning him. They are all enough. So the need for a positive act is very general. Anything, even encouraging words, the courts are going to say are enough to equal a positive act. So this is a pretty easy element to get over to prove. So usually if you do anything, you can qualify as a positive act. Now, keep in mind also, it includes not just physical help, like physically holding the person, but it does include that psychological help. So words of encouragement or something like that is enough also. So it can be anything. Positive act is pretty easy. Now, what about this? A citizen sees a crime about to be committed and fails to prevent the crime or stop a crime already in progress. Can the citizen be held liable for the same crime that the criminal just committed? So you're just standing there and you're watching something happen and you don't do anything. Is that enough for a positive act? And the court has said no. It has to be more than just your mere presence. So if you remember all the way back when we talked about actus reus, just being there is not enough. You have to do something more unless you have a duty to act. So we did talk about certain circumstances where you are legally required to do something. And if you don't in those situations, you can be responsible. But in general, you don't have a duty to do anything, American bystander rule. And so since you have no duty to act, then you can't be responsible for just being there, okay? But don't forget that exception. If you do have a duty to act, you must. Now, we talked about actus reus. So to prove actus reus, the only thing you have to show for criminal act is a positive act. But where it gets tricky is the mens rea. So for the crime of accomplice, there is actually 2 levels of mens rea that will have to be proven. So the prosecutor first is going to have to show intent to help someone commit the crime. So that means they intended and wanted to help them. So it's intentional. And you have to also show that the primary party committed, you intended that the primary party commit the crime. So it wasn't that you just intended to help. You also intended and wanted the primary principal in the first to actually carry out the criminal act. You had your own intent or want for that crime to be carried out. So that's where it gets tricky. You have to prove both things. First, that you intended to act. So he's holding the hands. So clearly that's intent to act. And then you would have to show that he actually intended or wanted that principal in the first to carry out the crime. And that's where it gets really tricky. So let's look at some examples. I lease an apartment to someone I know is going to use it for prostitution. Or the gun dealer sells me a gun she knows I'm going to use in a shooting. Or the telephone company provides me services knowing that I may use it for illegal gambling. Or a farmer leases 200 acres of farmland to a renter he knows is going to grow marijuana for sale. So remember, there's 2 things. Did they intend to help? And in all of these, yeah, you intended to help. You gave them the apartment. You got them the gun. You sold them the gun. You provided them with service. That's intent to help. But can you prove that all of these things that the person actually wanted them to commit the crime? So not just knowing they're going to commit the crime, they actually have an interest or a stake in wanting that crime to be committed. And the courts have said mere knowledge of the crime is not enough. So just the fact that you know somebody may commit a crime is not enough to satisfy that second requirement for mens rea. You have to show the person actually wanted it to occur. So let's say the farmer got a kickback for all the marijuana sold. Then you can show that they wanted him to do it, right? Or the phone company got a kickback for prostitution. Then you can show they had an interest and they wanted the underlying crime to be committed. But otherwise, it's very, very hard. So just knowing somebody may commit a crime, mere knowledge, is not going to satisfy the second mens rea. What about this? An undercover officer encourages a drug sale. Is he an accomplice? So he's encouraging a drug sale, so he has a positive act. And now we have the 2 mens rea, intend to act, intend the result, right? And we can say that the police officer intended to act because they voluntarily spoke and encouraged the drug sale. But does the police officer actually want the offender to commit the crime? And the courts have said no, they don't really want to. They're giving the opportunity and they're seeing if they are, but they don't really want them to commit the crime. So that's why an undercover officer would not count as an accomplice. We call them an agent provocateur. They give them the option and opportunity, but they don't really want, a police officer wouldn't really want anybody to ever commit a crime. So it won't fall under accomplice liability. Now, what about this? Thomas is upset that his girlfriend Lisa left him to marry another person. He states to his friends one night, "I want to know her whereabouts at any cost." His friends then visit Lisa's friend, Martin, to find out where Lisa is located. Martin refuses to tell Thomas's friends where Lisa is, so they kill him. Thomas is not at the scene when Martin is killed and did not intend for his friends to kill Martin. Is he an accomplice for the murder? So the question is, did he have a positive act? Yeah, he did say, "I want to know her whereabouts at all costs." That's a positive act. Did he intend to say that? Yeah, he voluntarily said it. But did he want the friends to actually kill Martin? So that would be, as a prosecutor, a really hard thing to prove, that he actually wanted them to do it. Now, remember, you are responsible for natural and foreseeable consequences. So maybe if you're a mob boss and you know that that's going to cause somebody to be killed, then that would be a different situation. But in general, you could not satisfy the second requirement of mens rea. Now, so remember, natural foreseeable consequences. but it's going to be a difficult case to prove. Okay, so what about this? Jack encourages his 6-year-old daughter to put rat poison in his mother's drink. The daughter does so and the mother dies. Can the daughter be criminally liable? No, probably not, because remember, under 7, then you have infant defense and you can't be charged for any crime under the age of 7. Now, is Jack criminally responsible as the accomplice, even though the daughter cannot be held responsible? So what this is asking is, if the primary, the principal in the first, has a valid defense, and so the charges are dropped against the principal and the first, can you still go after the accomplice, or do you have to have a principal in the first? And the Supreme Court said you do not need the principal in the first. You could still go after Jack because he intended to act. He had a positive act encouraging her. He wanted her to do it, and he wanted the results that occurred. So therefore, Jack could be an accomplice, okay? Now, what about this? Can an accomplice be charged higher than even the principal would have been charged? Purposefully and incorrectly tells Bob that Betty is having an affair. Harriet knows Bob threatened to kill Betty if she ever cheated on him. After hearing the lie, Bob flies into a fit of rage and kills Betty. Now, Bob is only going to be charged with a manslaughter, which is a killing in the heat of passion when you're provoked. It's a lower level homicide because he reacted out of emotion, right? But Harriet actually premeditated and plotted it and set the whole thing in motion. So can we charge her the higher level of murder in the first, which is premeditated, intentional murder, even though the principal is only going to get a lower homicide charge? The court said, yes, you can have those types of things. That will be acceptable. Now, remember, accomplice liability is when the person does not commit the direct criminal act, but are guilty anyway. So when you're looking at these, you're going to be tempted to think about the principal in the first and only focus on the principal in the first. But you need to look at, did anybody else help in any way? And did they intend the principal in the first to commit the crimes? If that's the case, that's accomplice liability, okay? Now, when you are an accomplice, even though you have to fit the requirements of accomplice, your punishment is going to be for the underlying crime. So if I'm an accomplice to murder, then my actual charges are accomplice liability and murder, and I'm going to be punished for the murder. So just like common law, you're treated the same if you're an accomplice. You will be punished the same way that the principal is being punished. Now, there is one specific defense that it goes with accomplice liability, and it's called abandonment. So if I am trying to encourage somebody to commit a crime and I change my mind, no, you know what, I don't want to do that anymore, I can abandon that crime. But in order for it to be a valid defense, I have to communicate to the principal in the first that I no longer want them to do it. So I have to specifically say, stop, don't do this anymore. And is very important. You need 2 things. You have to somehow render any aid that you gave ineffectual, okay? So if I bought him a gun to help him, I got to get that gun back, right? If you gave him words of encouragement, now you have to give him words of discouragement. So you have to actually convey to the principal in the first, you do not want to help them anymore. And you have to find a way to undo the help that you already did. If you do both of those things, you might get the judge to allow that as a defense. And then you can argue to the jury that you should not be responsible. Now, look at Penal Law Section 20.00. This sets forth the elements of New York's accomplice liability. So if you want to charge somebody as being an accomplice in New York, you look under Section 20.00. Now, when you read 20.00, you will see it's pretty much exactly what we said for common law, which doesn't always happen. So number 1, you have to have the mens rea for the underlying crime. So you want the underlying crime to be committed. So if it's an intentional crime, you intend to help and you intend the consequences of that help. And you have to intend to help in the first place. So it's kind of that double mens rea that we talked about. So you intend to help and you intend the underlying crime to be committed. And the actus reus, it says solicits, commands, requests, importunes, aids, blah, blah, blah. Those are all positive acts. So, and they try to just think of lots and lots of words that all means doing something. So any of those things are the positive act. So the rules we just went over for common law, we're really lucky. They're going to be the same rules for New York accomplice. Okay. Now look at Penal Law 2005. It will say there is times when a defense are not available. Okay. So whenever you say a section that is entitled no defense, that means you cannot use a specific defense. So in this case, they're taking away some defenses. And this is the same thing we talked about. You can't say as a defense, well, you can't hold me responsible because the principal in the first isn't responsible. We're not going to allow you to raise that as a defense in New York. So anytime you see a section that says no defense, it's the government taking away a defense that you may have been able to use. So make sure you understand that section. Now, we've mentioned before, sometimes you can't prove all of those elements on the wheel. So sometimes maybe you can't prove that second mens rea, that they intended the underlying crime to be committed. So they intended to help in some way. They just didn't intend the ultimate result that occurred. So then you can always drop down in New York to what we call criminal facilitation. So the person still helped prior to or during the actual crime, but they couldn't meet all of the requirements for accomplice liability. So if you're reading accomplice and you think, oh, I can't prove that, then you would want to drop it down to the next level of offenses, and that would be criminal facilitation in New York. Okay, now let's switch to accessories. So accomplices help during or before the crime actually occurred. Now we're going to talk about the people that happen after. So people that are not there, they're not part of the actual crime or even help before, but then after the crime is committed, they help the person somehow escape justice. Okay. Now for accessory after the fact, helping after the fact, you have to show intend to help. So the person actually did intend to help, intended to give them a car, intended to give them money, intended to destroy evidence. But there's more actus reus. You have to show that they knew that a felony was committed. So it's not that they just gave them money, but they gave them money knowing that the defendant committed a felony, that they helped someone, and then that help hindered prosecution or kept the prosecutor from being able to prosecute for a while. And what's really important is the accessory after the fact did not actually commit this felony, or him or herself. So they only helped after the crime was actually committed. So when you're reading a scenario, if you want to approve accessory after the fact, these are the mens rea and actus reus that you would have to prove. Now, under common law, remember, it didn't matter if you were accomplice after or before the fact. You were treated the same as the principal. So you would get the punishment as the principal in the first. We don't do that anymore. Now that it's just helping after the crime was committed, we consider that a little less serious. So we're going to give you a little less punishment. And you'll see that as when you're looking up the statutes. Okay. So what is accessory liability in New York called? We call it either hindering prosecution or obstruction of governmental administration. So if you think the person helped after the fact, we don't have a crime called accessory after the fact. It is either hindering prosecution or obstructing governmental administration. So when you evaluate your scenario, is it accomplice? Is it after the fact? If you decide after the fact, then these are the sections you're going to look at to answer your case studies. Okay. So there's one more quick concept that the book talks about a lot that I just want to mention really quick. We don't spend too much time on it. but we have this concept called vicarious liability. Vicarious liability is the ability to impose criminal liability for someone else's act with no independent mens rea or actus reus, and they transfer the acts of the primary to the person that helped, even though that we wouldn't normally do that. So let's look at some examples of when that would happen. So we have this thing called corporate liability. We believe that corporations should be responsible for the actions of their employees. So if you have an employee that does something criminal, you can transfer that employee's responsibility back to the owners of the company. That's called respondeat superior, that the employer is liable for the employee's conduct. And respondeat superior says, let the master answer. So there are certain circumstances like environmental, they dump toxins into the environment. The corporation itself is going to be responsible for those employee actions, even if they don't meet all of the requirements, that they knew what was happening and things like that. Okay. Now, a couple other times that you see it is like sometimes the owners of property can be vicariously liable for things that happen on their property, and parents sometimes are held accountable for what their children do. Those are situations of vicarious liability. Okay, so that always brings up this question: should parents be criminally liable for their child's actions? So Annie bullies another child on the internet and through social media. The other child commits suicide. Should the parents be held responsible for not supervising their child? Should they have the same criminal liability as the child would have had? Or Jackie invites friends over and they sneak alcohol from the parents' liquor cabinet. One of the friends drives home and is killed while drinking and driving. Should the parents be responsible for that? So these are really hard questions that sometimes come up. Should people be responsible for the other person's actions? So now we're going to start moving into using this in a real life situation. So remember, you're always the prosecutor. So what's going to happen is I'm going to give you scenarios, and you're going to have to analyze the scenarios and determine whether or not somebody can be charged with a crime. So the crimes that we've learned about now are accomplice, criminal facilitation, hindering prosecution, or obstructing governmental action or administration. So we now need to determine, can somebody in New York be charged with one of these parties to crimes? So we're going to go through an analysis. So when you're doing this analysis and you read the scenario, first always ask yourself, who committed the direct actus reus of the underlying crime? Who did the killing? Who did the shooting? Who's the primary? Who's the principal in the first? Okay. You're going to be tempted to forget about the party and want to focus on the principal in the first, which we're going to do for the rest of the class, but not this week. Right now, we're only looking at other people. So I put this in because if you have to answer that question, then you can force yourself to think of the other people. So first, who is the direct actor? Who's the principal in the first? Okay. If it's not all the parties, did anybody else help before or during the crime? If they helped before or during the crime, you're going to fall into the two choices for accomplice liability in New York. One is called accomplice liability, and the other choice is criminal facilitation. If you determine that they helped after the fact, then you're going to look at the accessory crimes in New York, which are hindering prosecution and interference with governmental administration. Okay. So I created this little chart to show you. So if you determine help before or during the crime, these are the sections for the crimes you're going to look up for the answers. If you decide they helped after the crime, then you're going to use one of these sections. These are your only choices. So on your answers for your chapter assignment case study or for the exam when I'm asking for parties or crime, these are your only choices. So if you catch yourself writing rape or murder and looking those statutes up, that is not correct. I'm not asking you what the principal did. I'm asking you what the parties of crime. So these would be your choices and your only choices. Okay. Now remember, if you choose accomplice, these are your mens rea, actus reus. And then if you have to drop because you can't prove, you're going to be in criminal facilitation. And then if you're help after the fact, these are your mens rea and actus reus. Now they're a little more specific when you look up the actual statutes. So you'd have to use the mens rea and actus reus from the actual statute. Now, what I have done is I posted this video called Accessory Liability in Action. It's actually a long video about talking about juveniles being charged with crimes. And we're going to watch 2 segments out of it throughout the semester. So what it does is this shows you a real life situation where somebody was accused of being a party to a crime. So what I would suggest is you open it up and then go to sections 4 through 6. There's little lines that define the section. So you can click on section 4. It's around 25 minutes in. And it takes about 10 minutes to watch just that one section. You don't have to watch, only have to watch sections 4, 5, and 6. But it really shows you an example of accessory liability in action. Okay, so that's all for this video. Hopefully you can print out the reference sheet and have that ready. And you can start looking at the discussion for chapter 7, which is talking about that concept of vicarious liability and also holding somebody as an accomplice. And it was the case of the shooting in Orlando of the nightclub and then going after his wife. So that is the discussion, and read through some of the materials and decide, do you think she should be tried as an accessor or an accomplice? Now, in the next video, we're going to take all of what we've learned and we're going to go step by step how we're going to answer our case studies from now on. And we're going to use parties of crime as a way to show you step by step how to answer those questions. So we will do that. Make sure you have your penal law with you. We're going to work through some examples. Have some paper so you can jot down your answers and then flip through to see if you got it right. Okay, so I will see you soon with the second video.